Your loved one has been arrested. You find them in the county jail. You check the jail website or call the sheriff, and you see these words, U.S. Marshal hold. You call a bonding company and they tell you, even if you post a bond, they're not getting out. What does this mean? And more importantly, what can you do about it? I'm Michael Lowe, a federal criminal defense attorney here in Dallas, Texas. Today I'm going to explain exactly what a U.S. Marshal hold is, what steps a federal defense lawyer can take to get your loved one released, and the critical mistakes you need to avoid. Let's get into it. A U.S. Marshal hold is what we call a federal detainer. It's placed on someone who's sitting in a county jail but has a federal warrant out for their arrest. The federal government is essentially telling the county, hold on to this person for us. We want them. The hold will generally not be released until the person is brought into federal custody. In most cases, the person in the county jail also has a pending state criminal charge. And here's what I always want to make sure of in these situations. My client does not get sentenced or go to trial on the state charges before the federal case is resolved. I'll explain why that's so critical in just a moment. Steps to get the hold released. So what can a federal criminal defense lawyer actually do to help? Let me talk you through the exact steps I take. Step number 1, I find out which federal district issued the warrant. This tells me where the case is coming from. Step number 2, I contact the duty magistrate in that federal district to see if an initial appearance is already scheduled. Usually there isn't one yet. Step number 3, I get the federal case number from either the U.S. Marshal or the duty magistrate. Step number 4, I contact the U.S. attorney assigned to the case and request that they initiate the process to bring the inmate into federal custody and schedule the initial appearance. Step number 5, if the U.S. attorney isn't available or isn't being cooperative, I can file what's called an application for writ of habeas corpus ad prosecundum. This is a motion asking the federal district judge to order the U.S. Marshal Service to bring the person into federal custody so they can face the federal charges. It's a way to force action when the government is dragging their feet. Step number 6, once my client is in federal custody, I make sure an initial appearance gets scheduled. Step number 7, if the government files a motion to detain, I do not waive the detention hearing. I schedule it. Even if the odds look tough, I believe in fighting for my client's release. Steps number 8, 9, and 10 involve either getting a bond set immediately if there's no detention, winning at the detention hearing, or negotiating with the U.S. attorney to withdraw their motion to detain. Let me explain what happens at the initial appearance, because it's an important step. At an initial appearance, the U.S. magistrate informs the defendant about the indictment or complaint and provides other required notifications. Under Rule 5 of the Federal Rules of Criminal Procedure, a person must be brought before a magistrate without unnecessary delay after the arrest. That's the legal requirement. In felony cases that haven't been indicted yet, the magistrate also must conduct what's called a preliminary examination, essentially a probable cause hearing. Here's something important. Unlike detention hearings, the government has to produce witnesses at this preliminary examination, and defense counsel can request to see those witnesses' prior statements before they testify. The critical mistakes to avoid. Now, here's where I need to get serious with you. This is the part of the video that you absolutely cannot miss. For some people, it might be tempting to ignore the federal hold. I've heard state lawyers tell their clients to just take a plea on the state case and hope the feds go away. They say things like, maybe if the state case is similar to the federal case, the feds will just drop it. Or if you get enough time on the state case, the feds will take mercy on you. This is terrible advice. Getting sentenced on a state case when you know there are federal charges pending is the worst mistake anyone can make when they have a U.S. Marshal hold. Let me explain why. The sentencing consequences. The first problem, increased sentencing guidelines. Federal sentencing is governed by the U.S. sentencing guidelines. Your sentence depends on two numbers, your offense level and your criminal history category. If you plead guilty and get sentenced on a state case before your federal case is resolved, that state conviction can get added to your criminal history calculation. That can push you into a higher criminal history category, which means a longer federal sentence. This is especially devastating for first-time offenders. That state conviction could disqualify you from the 0-point offender guideline, which can reduce your offense by 2 additional levels. That's a significant benefit that you'd be throwing away. The second problem, consecutive or stacked sentences. The U.S. Supreme Court ruled in Setzer versus United States that federal judges have the power to order a federal sentence to run consecutively to a state sentence. That means if you get 5 years on your state case and then go to federal court, the federal judge can say your federal sentence starts after you finish that state sentence. You could be looking at serving both sentences back to back instead of at the same time. If your loved one is sitting in county jail with a U.S. Marshal hold, time matters. The decisions made in the next few days and weeks can affect the rest of their life. You need a federal criminal defense attorney who understands how to navigate both the state and federal systems. Someone who can take the right steps to get your loved one into federal custody, fight for their release, and protect them from making costly mistakes. If you're dealing with this situation right now, I want to help. Give my office a call or visit my website at dallasjustice.com. I've written extensively about federal detention hearings, the Bail Reform Act, and sealed indictments on my blog. Links are in the description below. If this video was helpful, please hit that subscribe button and share it with someone who might need this information, or drop a comment below if you have questions. I read every single one. I'm Michael Lowe. Thank you for watching, and I'll see you in the next video.